Welcome to Josh Geyer's Knies 550 Critical Assignment. Today we're going to be talking about the community gymnasium and legal considerations that we need to consider while we're at the La Mirada Community Gym. Dr. Harbison, I just want to say it's been a pleasure this semester again, so looking forward to having you again next semester before we get started on this. La Mirada Community Gym. I chose it because it's my place of employment and it's something I'm passionate about. It's a recreation facility that has three primary areas for programming. We have a gymnasium, we have a multi-purpose room, and a fitness room. So the gymnasium can be set up in a few different ways. We mainly use it with 2 full-court basketball courts or 2 full-court volleyball courts or 2 full-court futsal courts with a divider curtain in the middle. For practice days, if it's volleyball season, we can set up 3 courts across that area, and that's how it's mainly utilized. The multi-purpose room is an 1,800 square foot facility. We do martial arts, dance, cheerleading classes. We have open table tennis play. And we have a fitness room with 3 treadmills, 2 ellipticals, 2 stationary bikes, 1 recumbent, and 1 Stairmaster. So those are the main sources of where we would have programming and some of the equipment that's used. Going from there, we build community there through recreation. That's kind of what the professional recreation is. So the way we build community is through our programs, and programs provide liability. So that's just part of the game. Some of the programs we offer are youth basketball leagues, youth volleyball leagues, youth flag football leagues, youth futsal leagues. We have adult basketball leagues 2 nights out of the week. We do Sunrise Senior Hoops for 55 and over, and I can tell you that there's a few 80-year-olds that are participating in that program. We have an open table tennis program. We have dance classes, cheerleading, martial arts, and we do community dances for junior hires and also older adults or just parent-child dances. So there's a lot of things that have moving parts. So with that, we have some liability that we need to consider. So jumping into legal issues, first one of the most common injuries in any fitness facility is use of treadmills. So one of the high-profile cases recently was the Jimenez versus 24 Hour Fitness. Went to the Court of Appeals in 2015. Edelvita Jimenez fell off the back of a treadmill and injured her head. So what happened was she was on the treadmill, she fell backwards, she hit her head on a piece of equipment that was behind her that was approximately 3 feet 10 inches behind the back of the treadmill. Now, the manufacturer guideline for that particular treadmill said the required clearance area should have been 6 feet. So immediately, one of the things that was brought up was negligence. But not only negligence was brought up, she signed a waiver of liability, but she claims there was fraud. So we have fraud and negligence that we're talking about in this specific case, because there was no translator translated into Spanish for her. So the Court of Appeals ruled in favor of the plaintiff, so she was awarded the judgment. So treadmills is our first thing that we need to consider as far as legal issues go. And then the next one here is flag football. So let's see if I can say this right. Segoviano versus the Housing Authority. So Francisco Segoviano fell and injured his shoulder while participating in an organized flag football game. It was actually a recreation professional that was running this particular game that they had going on, and it was sponsored by the Housing Authority. So the lawsuit that was brought forward was about negligence, and the trial court ruled in favor of the plaintiff and said that the plaintiff was 30% at fault, but the defendant, it was said that they had 70% of the fault. So the initial ruling was that the defendant would pay the plaintiff $2,800 for his injuries, which is approximately 70% of the hospital bills that he incurred. It moved on to the Court of Appeals, and the Court of Appeals overturned the original ruling, saying negligence was a moot point because the plaintiff knew the inherent risk involved with playing football. So ultimately, the defendant came out on top on this one, but it's just something we need to consider when we're setting up for playing flag football and any organized sport for that matter. Next one is volleyball. Luna versus Vela. Court of Appeals in 2008. Fabian Luna suffered a fractured elbow when tripping over an outdoor net system, volleyball net system. So, trial court ruled in favor of the defendant, saying that they were not at fault. The Court of Appeals, however, overturned the original ruling, saying further proceedings were necessary and called for Luna to recover its costs of the appeal. So basically what happened is the plaintiff in this case tripped over one of the net lines that was holding up the volleyball pole. So that is what caused the injury. So equipment use is a huge one, to make sure we're setting up properly, and then also making sure people are aware of where those things are and marking them accordingly. Risk management. The first thing on here is treadmill. That was our first legal case that we talked about. So first thing for us is there is potential for injury, right? So people fall off the back of treadmills. I don't want to say all the time, but often enough to where it's a common issue. And one of the things that we do to mitigate risk at my facility, and we should do this at all fitness facilities, is making sure people are signing liability waivers before they're participating. So we have it clearly when they buy their membership, they sign a liability waiver. And that's just kind of a basic thing that should cover everything that we do at fitness facilities. The other thing is to mitigate risk following the American Society for Testing and Materials, so ASTM, of manufacturing guidelines for clearance protocols. So the reason I say following the ASTM guideline is because they actually have a stricter guideline than what the manufacturer does at this point. So according to Herbert, 2015, ASTM currently requires a 6 foot 6 inch rearward clearance and a 1 foot 7.7 inch of side clearance on each treadmill. So if someone falls off the back of that, hopefully they're not taller than 6 feet 6, and they don't hit their head on something that's obstructing them from falling onto the ground. So basic guideline for treadmill would be to have the clearance in the rear at 6 foot 6 inches and the clearance on each side at 1 foot 7.7 inches. So one of the other things we can do to mitigate risk would be to just evaluate the layout of all the equipment, not just treadmills, since we talked about having several pieces of equipment in this particular fitness room, and making sure that we're adhering to the proper clearance to mitigate risk. The next thing we have on here is flag football. So liability waiver is required. We have to make sure to mitigate risk that we have a safe field to play. Our standard of care, we want to be in accordance with the safety standards of the Southern California Municipal Athletic Federation, so otherwise known as SMAF. They're kind of the Southern California organization that oversees a lot of the different sports for municipal government, so they've got some safety guidelines that we try to follow. Not just try to follow, we have our own standard of care at the city of La Mirada, and we establish that kind of in accordance with what they're requiring. The other thing that we do to mitigate risk is train staff on safety protocols for heat illness, concussions, bloodborne pathogens, and ethics of coaching. So our staff and our volunteers are all trained, and we even try to get the parents in on the knowledge as far as that goes. Next we have volleyball. Again, there's equipment here, so we have high tension wires that hold up the net. We have metal volleyball poles. We have a netting system. People are jumping. It's a high impact sport, so there's a few things that can happen while people are playing. So some of the things that we do to mitigate risk as far as that's concerned is creating a standard of care, using our National Federation of High School Associations safety standards. So for me, I coach at the high school level, and I feel like I know we use SMAF for the other one, but the high school standards are a little stricter than what the SMAF standards are. So that's something that we try to follow. We're a conservative city, and we really want to do our best to avoid any litigation. The other thing we do is train staff. So it's very similar to football, inspecting the equipment and maintenance of the equipment. So those protocols are something that we teach our staff, as well as setting up and breaking down guidelines for volleyball net systems. Training staff volunteers on safety protocols, again, for heat illness, concussions, bloodborne pathogens, and ethics of coaching. So poles is a big one because those are kind of heavy, so we make sure people learn how to lift those properly and install them properly when they're putting up the netting system. And then the high tension wires or ropes, like I said, hold up the net system, so there is risk as far as those are concerned. So we need to make sure that we have the proper padding, those things are covered before people are participating. Employment laws that we should consider. Civil Rights Act of 1964 Occupational Safety and Health Administration of 1970, and the newest one is Americans with Disabilities Act. So as far as civil rights is concerned, in 2011, Butler versus New York Health and Racquetball Club, there was a yoga instructor there who was a female, and she's already an underrepresented class. She was a female. She was a minority as far as her race was concerned, and she was paid less than people that had less experience than her. So she took them to court, and she ended up winning. As far as occupational safety is concerned, Buhner versus Neshaminy School District, volunteer was injured while moving a volleyball pole. So proper training should be provided for your staff and volunteers just to make sure that they're assisted in doing the proper movements when they're moving heavy equipment. And then the most recent one, and this one I think is the most relevant. I mean, they're all relevant, but as far as where we're moving, Americans with Disabilities Act, ADA compliance, it's something that's newer on municipal government radar as far as accommodations are concerned. So this one was specifically Anderson versus Little League Baseball, 1992. Coach was told he was not allowed to be on the field to be a base coach because he had a wheelchair. So he took them to court, and basically the moral of the story here is that we need to make every effort to accommodate people. So make reasonable accommodations for volunteers, employees, and patrons. I know we're talking about employment law, but it's really about if we can, we should, and we need to do everything that we can in our power to allow people that same opportunity. Application. So education and training to raise awareness. That's something that we would do with staff, volunteers, and even patrons. So regular meetings and trainings with staff members and volunteers, create scenario-based practical application opportunities during training, and create training manuals with safety protocols for all equipment used in the facility. Another thing we do is require signed waivers for any and all use of the facility, and it's outreaching programs. So outreaching, I say that because we have football, it's not housed in the facility, it's kind of housed outside of the facility, but it's still part of the gymnasium programs. And then get staff and volunteers certified if at all possible. So they're qualified, but if we can get certifications, that just backs that up. So it's something that we do if we can. Faith integration. I kind of have a 3-tier thing here. Rooting your thoughts on the right things to do helps you live by the Spirit. And then from there, we just need to remember that we're working for the Lord. But if we start at the top there, root your thoughts on righteous things, Philippians 4:8. So whatever is true, this is one of my favorites actually. Whatever is true, whatever is noble, whatever is right, whatever is pure, whatever is lovely, whatever is admirable. If anything is excellent or praiseworthy, think about such things. So putting our mind in a place where we're focusing on the right things to do, I think as supervisors, that just allows us the opportunities to be a light when we're in our workplace, whether you work for a Christian organization or not. So you're just getting your mind right first, and then from there, it's living by the Spirit. So Galatians 5:22-23 tells us, but the fruit of the Spirit is love, joy, peace, patience, or forbearance, if you will, kindness, goodness, faithfulness, gentleness, and self-control. Against such things there is no law. Since we're talking about legal aspects, we just need to remember those fruits of the Spirit. No one's preventing us from doing the right thing and showing God's love. Exemplifying joy, having peace, and showing kindness and goodness. And all those things that are listed there are not against the law. So we should be striving to do that. And for me, the thing that gets me through a lot of days is working for the Lord. Colossians 3:23. Work willingly at whatever you do as though you were working for the Lord rather than for people. And this is one that I have to remember constantly. Like, I'm not in it for the people I'm working for. The job that I do should be to glorify Christ and what He's called us to do. So my job, the way that I look at it is whatever I'm doing, I do it to the best of my ability, and I do it as if I'm before God Himself. And the job that I do should be a reflection of that sacrifice that I should be bringing to Him every day. So those 3 things are what I focus on as a supervisor. I hope that helped you a little bit. I know it helps me a little bit every day. References, here's the list. Wanted to make sure I included that because we referenced several court cases, and we had some other references that we used in there as well. Again, thanks, Dr. Harbison. This has been a great semester, and looking forward to